So a landlord has mandated an estate agent. So let's, in this example, say that the seller has mandated the estate agent to find a tenant to maybe manage the property. So more often than not, we're speaking about management mandates where the property is going to be managed by a single estate agent over a period of time. Now, if the seller sells the property to a buyer, although the lease agreement in itself passes over to the buyer, the mandate with the estate agent is not subjected to Heergat Verkoop. It's just a normal contract. It's just a normal contract. There is no obligation on the purchaser to take over this contract. Now, this question comes with many different issues and debates, because the problem of the agent is to say, but if, for example, the seller signed a 12-month management agreement with me, and now he sells the property, now I lose the management of the property. Yes and no. Remember, as an estate agent, you would still have recourse against the seller. So if the seller has made a promise to you and has not been able to keep it, and because of the transfer of the property, that mandate with the agent has been terminated, obviously the agent still has a claim against the seller for breach of contract, as anyone would. So remember, the Heergat Verkoop with tenant and landlord is actually quite an exception in our law. It's something that's built into our law over centuries. But when it comes to agency, this is a normal contractual claim. And being a contractual claim, if the agent feels aggrieved because a management agreement has been terminated early, they do have recourse against the seller, but they do not have any claim, unfortunately, against the purchaser of the property. So if the purchaser of the property chooses not to sign a mandate with that particular agent, then so be it. Remember, the tenant belongs to the landlord. The agent simply has recourse against the person that he acquired the tenant for. And this brings us into a whole world of conversations around how do these mandates work? Can you tie in a landlord for 12 months? Can you charge procurement? Can you charge management? What happens if it's terminated? And that's a very specialized conversation. As an agent, it's up to the agent to make sure that their mandates are in place. But as a seller and a purchaser, it's important to know that you're not obliged to take over a mandate, but you can. But it would be a fresh mandate, and you would mandate this estate agent yourself to manage the property for either month to month or a fixed period of time. But that's obviously between you and them. The failure to disclose that there is a lease agreement, a valid binding lease agreement over the property, is a material defect, because at the end of the day, the person's usage or desire on how they're going to use the property has to be taken into account. So it is a material defect. It is a breach, a failure to make a disclosure, and there is definitely recourse between by the purchaser against the seller of the property. However, one has to look at the practical consequences of this. The reason or the purpose for which the property was purchased has to be taken into account. If the purchaser bought the property with the intention of leasing it out and receiving rental income, and by virtue of having this tenant, they are in fact receiving rental income, then you may have a claim as such, but there is nothing that you're actually going to be able to receive because you are still utilizing the property for the very same purpose. And so your damages are basically nil. This particular issue normally arises when the purpose of using the property are for things like a residence, where I sell my existing property, I buy a new property, I want to move into it, and now it turns out that there's a tenant in there. And same way as if there was an unlawful occupier in there, that is a breach, because now I was going to utilize that property and I cannot utilize that property anymore. Bear in mind again that if the tenant is paying rent, the damages that you are suffering as a new purchaser are limited because you're at least receiving the value of occupation. But there is still a case to be made out that now, unfortunately, you've incurred unforeseen expenditure by having to stay at an Airbnb unknowingly, and maybe there is a claim for damages there. And the other circumstance under which this type of claim arises when the rent that is being charged to the current tenant is under market value. And that is a problem, especially when selling to investors, because investors buy properties with the intention of renovating them and increasing the rental value, the income and revenue that they can receive from a property. So unfortunately, if you have a tenant on the property that's paying under market value and now this investor stuck with the tenant, then there is definitely a good claim for damages, being the difference between the rental received and the rental that could be received. At the end of the day, however, let's say, for example, you wanted to develop this property out and now you're stuck with it. There are cases to be made where one could look at cancelling the transaction, terminating it. But if you've taken transfer of the property, doing this is a bit of a headache. If you haven't taken transfer of the property and it's still in the process of transfer, then by all means have a go at cancelling or terminating the agreement if you feel like this breach or failure to disclose is material enough and goes to the root of the agreement. So the tenant's rights are protected by our law. They've always been protected by our law. So as a seller, you cannot simply ignore the fact that there's a tenant on the property. You have to take that into account. The Rental Housing Act does make provision for the termination of lease agreements under certain circumstances. And there are some practitioners that argue that one of those circumstances, for example, is the sale of the property or a person wanting to move into the property, a landlord wanting to move into his own property to live. Whether this is the case or not is constantly being adjudicated upon. So you as a landlord, if you intend selling the property and you don't want a lease to be attached to it, at least have a look at it and have a conversation with the tenant ahead of time. So it's very important to be proactive with this, not simply assume that the lease will come to an end automatically. As a purchaser, please make sure you know who stays on the property. When you're doing viewings, it's quite apparent that there's somebody staying on the property. And I rarely see a situation where a person does not know that it happens to be a tenant. The estate agent would have to disclose that it's a tenant, and technically the seller in our law would have to disclose that it's a tenant. But you need to ask the question, also make sure, because if it is a tenant, you need to look at that lease agreement and make sure that you're happy with it, because it does not simply mean by buying a property you can renegotiate the lease and charge whatever rent you want. That is not the case. You have to wait for the lease to end. Then the last thing, estate agents out there, be careful with this. Your mandates, and I'm sorry, but I've seen this, 90% of the market, your mandates lack detail. Unfortunately, estate agents rely on the fact that a lease agreement is entered into, and there's somewhere in the mandate it ties the mandate for management to a 12-month fixed-term lease agreement. Unfortunately, there's also termination notices and termination periods sometimes contained in those mandates. So you have to read them together. And unfortunately, because of that, a landlord may cancel a lease agreement. So don't waive your procurement commission without having a conversation with the landlord that it will be levied if the management is terminated early. So bear in mind, you're running a business. Don't simply rely on what you feel is industry practice, because in the industry, I find that there's many deviations to practice. And unfortunately, nothing is set down clear enough to be able to easily determine what you are and aren't entitled to unless it's in writing.